Hello, everybody, and welcome. Okay, so there's been some new filings in the Letecia Stauch case. Now, we do know, let me just get my book here to make sure. I believe it's April 3rd her trial is starting. No, that's Lori and Chad. March. March 20th, her jury trial is going to start. Now, what has happened is Letecia has said that she does not want a jury trial, and she's filed some paperwork also for a change of venue. So we're going to go over that. If you haven't subscribed, please hit that subscribe button, hit that notification bell, share this out with your can, leave a comment in the section below, and let me know what you think of what's going on with this case. But it does look like we are finally going to be moving forward on March 20th. But that doesn't stop Letecia from pulling a few more antics, and I'm sure there's going to be a lot more before this trial gets started. Okay. So what I'm going to do is I'm going to bring up the paperwork that was filed. It looks like it was filed on December 1st. But it's just recently hit the files. So let me just get that up here. So here it is. So I'll go over this. I'm going to be skipping a lot of like the little nitty gritty things that don't need to be always referred to, rules and stuff like that. It's a waste of time. So the district attorney, Michael Allen, has filed the people's position regarding the defendant's request to waive a jury trial. Now, they haven't discussed the change of venue yet, so I would assume that that would have to be discussed before they take up any thing about a jury trial or not. Like, where are we even going to have this thing, right? So I think there's a few things that still have to be discussed before a lot of other things happen, but Leticia's known for, pulling her antics and stuff like that. So I think Michael Allen is trying to get ahead of all of it. Now, Letecia has already said she does not want a jury trial. She doesn't think she's going to get a fair trial with a jury, but there's certain cases that you can't, or the DA can at least say, no, we're going to object to that. And that's what they're doing here. And they give their reasons why. So let's read through this quickly so you guys know what's going on. Like I said, I want to keep you guys up to speed because I do feel like Letecia is going to be pulling a lot more antics between now and March 20th when her trial is supposed to start. So as long as we're kept up to speed so everything is fresh, and we'll see what these latest filings are right here. So here we go. The People's Exhibit 33. This is the filing. This is 33 things that they filed. People's position regarding the defendant's request to waive a jury trial. The District Attorney of the 4th Judicial District of the State of Colorado, Michael J. Allen, and his duly appointed Deputy District Attorneys respectfully moves as follows in P33, People's position regarding the defendant's request to waive a jury trial. The people hereby object to the defendant's waiver of her right to a jury trial and further states as follows. On February 4th, 2022, the defense filed an unnumbered motion titled Motion to Change Plea to Not Guilty by Reason of Insanity. In that pleading, the defense notified the court that the defendant wished to waive her right to a jury trial and to proceed with a trial with the court, citing Colorado Rule of Criminal Procedure, Rule 23. Pertinent to the people's position here, the defendant filed a D37 motion for a change of venue on December 28, 2021. The people filed a responsive pleading on January 7, 2022. Applicable law. Section 25 of Article 2 of the Colorado Constitution provides that no person shall be deprived of life, liberty, or property without due process of law. To be clear, an accused does not have a constitutional right to waive a jury trial, and this is cited in People versus District Court of Colorado 17th Judicial District. Okay, and it goes into citing the cases that they are referring to. Further, in the absence of a statutory authority, the courts have recognized that while a defendant may have a common law right to waive their right to a jury trial, this right is not absolute, and it cites, again, precedent. As the rights afforded to the prosecution, CRS section 1610-101 is clear in that the people have the right to refuse to consent to a waiver of a jury trial. However, this right is also not absolute. The defense highlights criminal P23A5, which allows a defendant accused of a felony to waive their right to a jury trial with the consent of the prosecution. Criminal P23A5 does not qualify this waiver based on the level of the offense. Conversely, Section 18-14062 explicitly states that the waiver of a jury trial by an accused does not apply in a Class 1 felony charges. Given this incongruity with the Colorado Supreme Court recognized that an irreconcilable conflict exists between criminal P23A5 and section 18-14062, and ultimately resolved the matter by declaring that section 18-14062 is controlling. And that was cited in Garcia versus the People, 16P2D. We're not going to read all that little stuff here. However, the ruling in People versus Garcia does not directly address the waiver of a jury trial in capital cases or Class 1 felony charges, and there is still a lack of direct statutory guidance. In the absence of relevant statutory authority regarding capital cases and Class 1 felony cases, the Colorado Supreme Court previously ruled that the prosecution must consent to the waiver of a jury trial, and the trial court cannot grant the waiver over the prosecution's objection. And that is cited in People versus Davis. To be clear, the ruling in People versus Davis is also not absolute. Subsequent rulings in District Court 843P2D, blah, 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 and District Circuit, City, and County Courts indicate that when construing Section 18-14062, the trial court should consider the due process rights of an accused, such as the prosecution alone cannot compel a jury trial in circumstances where a defendant may not receive a fair trial. Procedurally, the defendant's burden to raise due process concerns and clearly articulate the circumstances which would preclude a fair and impartial jury trial, specifically when the people object to the waiver of a jury trial. District Court 843P2D at 11. Okay, the defendant claims that she is prejudiced because it would not be possible to select a fair and impartial jury in this case. The trial court can consider the extent to which a change in venue may cure basis or prejudice against the accused when considering the issue of the waiver. Ultimately, the trial court makes the determination as to whether the waiver of the defendant's right to a jury trial should be granted over the prosecution's objection, considering the specific due process concerns. Regarding concerns of publicity in terms of a change of venue request, the burden is on the defendant. So the defendant has to prove that because of publicity in the case, that there's no other means to go about this other than change of venue, and the burden is on her to prove that. Further, to warrant a change of venue, the trial court must consider factors sufficient to show that the publicity is so massive, pervasive, and prejudicial as to create presumption of an unfair trial. And they're citing Hawkins 361P3 out 1036. These factors include the size and type of the locale, the reputation of the victim, the revealed sources of the news stories, the specificity, oh my God, I can't talk today, you guys, of the accounts of certain facts, the volume and intensity of the coverage, the extent of comment by the news reports on the facts of the case, the manner of presentation, the proximity to the time of trial, and the publication of highly incriminating facts not admissible at trial. This standard is stringent one and is difficult to meet. Prejudice exists only in rare and extreme circumstances, and they've cited other cases where United States versus McVeigh and Shepard versus Maxwell, Rio versus Louisiana. The people do not consent to the defendant's waiver of a jury trial, and the defendant's request to proceed with a court trial should be denied. The people hereby object to the defendant's waiver of a jury trial and thus do not consent to the defendant's request for a court trial. Given the people's objection, the holding in District Court, City and County 953 P2D at 184 is determinative. Specifically, it is the defendant's burden to show that she cannot receive a fair and impartial trial, and she has not made that showing. To date, the only evidence the defendant has put forward to the court to consider is her assertion that there has been a large amount of publicity in this case, and that by the virtue of this case receiving this publicity, her right to a fair trial by an impartial jury is threatened. This assertion is not supported. Given that the defendant has only made an unsupported assertion that she faces a threat of not receiving a fair trial and impartial jury trial, she has not met her burden. The court should deny the defendant's request for a waiver of her right to a jury trial at this time. While the defendant has filed a D37 motion for a change of venue, the court has already ruled that it cannot address the issue of venue until jury selection begins. In the context of the defendant's request for a change of venue, the court may seek to readdress the matter of her waiver of her right to a jury trial when the court rules on the D37 motion for change of venue. It is important to note that in the state of Colorado, there have been a number of high-profile cases involving large amounts of publicity. Oh my gosh, you guys, I'm sorry, I can't talk today. Where a fair and impartial jury was impaneled without the need for a change of venue. So they don't want the change of venue, and they do not want the no jury trial. Wherefore, the people respectively request the court deny the defendant's request to waiver her right to a jury trial at this time. And this was submitted on the first day of December, but it just hit the record. And this is just the certificate of service. Okay, so as we see it there, you guys, she doesn't want a jury trial. She wants a change of venue. I mean, I do believe that this is just going to get worse and worse and worse. I think that there's going to be some more personal letters from Letecia to the judge again. I do think that we're going to see more of that. I do think that there's going to be, we're still waiting to see what this ace in her hole is. If you guys remember when this case first started, she says, I'm going to be found not guilty. I have an ace in the hole. Well, I still don't know what that ace in the hole is. I have a funny feeling I know what it is. But we have yet seen her pull this so-called ace in the hole. She's delusional, and I think that she's just trying to prolong this as long as she can. She obviously does not want to be present in court, but she is going to be forced to come to court, and the judge has made that quite clear and did force her to come to court at her last hearing. So we are waiting now for the outcome of this last evaluation with the EEG and stuff like that with this crazy doctor that thinks that Letecia is not guilty because of some kind of head injury or something like that. And this is the reason why she might have committed these crimes, etc., etc. But the head injuries that she speaks of were caused after the fact. I believe she threw herself off her top bunk and whacked her head, and as we heard in other filings, that her head was bleeding and they didn't give her proper care and blah, blah, blah. Now, that happened after the fact. Now, so as far as I'm concerned, I think the district attorney's office has a good fight with that. If this doctor is trying to say, look, she has some scarring there or some injury there to the head, I think the DA is going to come back and say, well, those injuries were caused after the fact when she was incarcerated on these charges. Now, I don't know if these tests that are being done, where she's got to wear a monitor for 72 hours, and I forget what the other test is. There's a couple of tests, an MRI, I think, or something. Um, but I don't know if they can, if there is an injury visible on these CAT scans or EEG, whatever they're doing on her. I don't know if those tests can show when that injury happened, but we do know she has not ever complained about an injury prior to this. I believe that the DA has her medical history, so there would be something in the history before the crime was committed that she had some kind of head injury. That would have been well documented. I do believe that she is trying to now say that she had a head injury during this time when she committed the crime. She thinks that this is going to show up on this MRI and EEG and whatever. But I do believe she intentionally harmed herself in jail via throwing herself off the top bunk when she smashed her head. And I do believe that that's what she's going to try and use and say that that was present before the crime was committed. Therefore, she had a head injury and she didn't know what she was really doing. Lord knows what she's going to try and do. That's just my take on it, you guys. We'll have to see what comes out when these test results are brought back in and discussed. That should be soon, because that was all supposed to be handed back to the court the beginning of, she was supposed to be done, I believe, by the December 1st, and they were supposed to have all the results and everything back by, I think it was, let me see, I think it is the 22nd that all those results are supposed to be back. Let me just see what, yeah. All motions are to be filed by December 22nd also. And all motions have to be resolved by February 2nd, because her trial is starting March 20th. So I'm going to be anxious to see what motions are filed, what this quack doctor, and I call her a quack because I think she is. I know she is an older doctor, I believe in her 80s, but her methods have been really questionable in the last maybe decade. So she's tried to get off people like the likes of, I believe it was Ted Bundy or somebody equivalent to him, saying that, oh, he had this head injury and I can prove like through these EEGs. And anyway, I call her a quack. So we should know what the results are of that, what they're going to use of that. Everything has to be in by the December 22nd, any motions, anything. So that is tomorrow. So I'm going to be watching the record for those filings and to see what has come of this 72-hour EEG and the MRI and whatever, and see how they're going to use it. And that I'm going to say it ahead of time. I do believe that they're going to try and say that she had these injuries prior to her committing the offense. We'll have to wait and see. I don't think it's going to fly. Like I said, the DA has all her medical history and whatnot, so I think that they can squash anything that this quack comes up with to try and get Letecia off these charges. But we'll have to wait and see. I will be waiting for that. I hope you'll be waiting for that, because I'm going to be bringing it to you. I have been really swamped this last week, you guys. I haven't been able to be present on the channel as much as I would like. With my daughter going into that labor, they had to stop her labor. There's just a whole bunch of things going on within the family unit itself, and those will always take precedent over anything else. Although I do try and still get breaking information out to you guys, and I will still continue to do that. Now, this Sunday coming, we will not be having the mini reads. We will be having them on Boxing Day. So if you do want to have your very own mini read, make sure that you're with us on Boxing Day for that. And that will probably be around noon, 1 p.m. Eastern on Boxing Day. We'll get the mini reads done and whatnot, catch you guys up on any information that's come out. I do have a couple of cases that I have been asked to do very first readings on. They are recent cases. So I am trying to find, in between all this hectic stuff going on at home, I am trying to find some time to get those reads in. Okay. So with that being said, you guys, make sure you're subscribed and make sure you got your notification bell on so you are made aware when things do pop off and I jump on here and go live. Keep an eye also on my community tab. I put a lot of information out there also. So if I do not see you guys before Christmas, I want to wish you a very Merry Christmas and a safe and happy New Year. Please take care of yourselves. Please stay safe. I love you all to the moon and back, and I appreciate each and every one of you. Bye-bye for now.